Welcome to this week's lecture for BUL 3130. We're going to begin our look at business entities. We'll cover this week limited partnerships. We'll talk about LLCs or limited liability companies before we go into corporations, which we'll cover over the next few weeks. So we're going to go ahead and get started. Let me get this shared for you. All right, so this is going to be chapter 32. Limited partnerships and limited liability companies. We will talk about those two at the end. We'll discuss a little bit about a couple of other businesses that have the unincorporated status. Everything we'll talk about today, they're considered unincorporated. They haven't filed articles of incorporation. They do not fall up under the same rules and regulations as a corporation would, but they do each one have statutes that state how they will be ran and what can go into them, how they can be done, the ways they're formed, the ways they're dissolved, and everything in between. All right, so let's go ahead and get started with our limited partnerships. A real quick word about partnerships before I talk about the limited version of these. So a limited partnership is going to be a step above a general partnership. In a general partnership, you have two or more individuals that come together, decide to form a business. They're going to do it as partners. They'll take on whatever roles that they decide between the two of them. They'll have a partnership agreement that they'll set up, and it'll be based upon the statute that covers partnerships in the state to which they are working. A limited partnership goes one step above that and brings in someone who has a limited status as far as what they are doing. So in a general partnership, the general partners are liable for everything in the business. They're liable for the money that goes in and out. They're liable for any accidents. They're liable for any liabilities that form as of issues that arise with the partnership. If the partnership gets sued, they are individually liable for whatever that tort may be. So they carry all the liability. Well, sometimes you bring in limited partners. A limited partner can be there for the purpose of funding. Normally, a limited partner comes in and they will bring funds to the table. They do not manage, they do not have those daily in and out decision-making duties that the general partners would. So that gives them that limited status. The definition is a partnership formed by two or more persons under the laws of a state, having one or more general partners and one or more limited partners. You can have as many general partners as you desire, and then one limited partner added to those will form then a limited partnership, which carries a different status, once again, than what that general partnership does. So with see if I can move this out of the way so it's not covering the screen there. So with a limited partnership, the formation is when there's substantial compliance with the state statute that designates what a limited partnership is. We're not going to go into the statutes and dig those out, but those statutes will put a definition upon the partnership, upon what the limited status is. When we consider what a person having limited liability inside of a partnership would be, it'll be designated by that statute and it'll describe that. The way that it's formed is going to be, of course, filing a certificate. They sign this, and it is a signed certificate of the limited partnership. The signatures are those who are involved in that partnership who have a say in it, or those who are limited, and they'll be designated as such when you fill out their certificate when you're forming that. A good rule of thumb with a partnership or a limited partnership is to have a partnership agreement. It's not a requirement by statute. In the state of Florida, we do not require a partnership agreement to be in place, but it is a good spot to set up the responsibilities of the general partners and to discuss the way things are handled for the limited partners. Now, there are certain things that will happen based upon what the statute says, the way that payments are done, the way that taxes are done. Those things are specifically set up. They can't be changed just because a partnership decides they want to do something different. They're based upon that. You can only build upon that framework that's already in place by the statute. Just like with any of the other things we study and we look at when it comes to law, we're always looking at what the law says and using that as the legal framework to which we build upon. So with a partnership and a limited partnership, whatever that statute is, we build upon that. When we study LLCs here in a few minutes or talk about those, it'll be the same thing. There is a framework, a law statute that's set up, and you build upon that. So the name of it would be the name of the partnership. Now, if you think about what some partnerships are, you have medical professionals that form partnerships, and some of the biggest professional type partnerships that people think about are law firms. In a law firm, you may have different levels of partners. You could have partners who are the managing partners, and that would be something. If you think about some of the more known law firms, a Farrah and Farrah, a Morgan and Morgan, their names are on or part of the name of the law firm itself. It's just simply Morgan and Morgan and Farrah and Farrah. You have others who have just one person's name. They're the one who is controlling the decision making. They will do the day-to-day running of it through people they hire in. They make decisions on who's hired, who's fired. They control everything to do with it. They're managing the business. They're a partner that has management duties. A limited partner does not. If a limited partner's surname was to make it into the name of the corporation or name of the company or the name of the business, it's not a corporation. If it makes it to the name of the business, then they will lose, in most instances, lose their limited liability. Limited liability is very important to someone who wants to be a limited partner. They want to make an investment. A limited partner is the way that a partnership can receive investments. All right, the same as how a big corporation can have investors, no matter if it's a, one that is publicly traded or one that is closely held. They can have investors who put money into it. In a limited partnership, those limited partners become the investors in a lot of instances. They're bringing in money or maybe an expertise that they give some type of instruction, something that they're getting a return on in most instances. And when they do that and how they set that up is based upon statute once again, and done very carefully to keep them from losing their limited liability. In other words, if the partnership gets sued, if they're a limited partner, their only chance of loss is whatever they have put in. Nothing can be done to jeopardize their personal assets. Nothing can be done to jeopardize any other businesses they may have. All right. So it's just based upon what they've put into it. That's what limited liability is. So when we talk about our LLC here in a few minutes, that's the same way. We have limited liability. So limited liability means your limit of your liability is based upon what you have put in to the business. If you maintain that status. All right. Ways that a person could lose that, of course, is including their name, which makes them look like they're managing. They're a part owner in a partnership. If they do that, then they could lose their limited liability. If it can be shown that they were doing more than just making this contribution into it, those contributions, of course, could be cash, property, services, or a promise to contribute cash, property, or services to the partnership. If it goes beyond that and it's shown that they have made decisions about who is working, how day-to-day operations are going to go, they would lose that limited status. All right. That makes them a partner. They're making decisions. So they have to be real careful to maintain that limited liability by doing just what they have planned to do, contribute something to it without making any decisions, without having any say-so in the day-to-days. They're just putting in these contributions and only expecting back what their return would be on it. Now, a defective formation of one is if you do not have a certificate filed, or if it is filed, it's not substantially does not substantially meet what the statutory requirements, that framework, then it can become defective, and it would mean that that limited liability once again is in jeopardy. All right. So when someone decides to be a limited partner, and I'm going to say this a couple of times, when someone decides to be a limited partner, they are doing so because they want to help out a partnership, but not have the liability that goes with running the partnership. That's why a lot of people will be a limited partner in something, is to keep from losing that liability. Because when we have those first few stages of what a business can be, we have that first sole proprietorship where it's one person or a married couple who form a business and they manage that business. They carry all the liability, they carry everything into it. Then we can step up into a partnership where two or more people come together to form a partnership and do so by filing the right paperwork for that. And then we get into where we begin to have limited liability for someone who is involved in it. And that's when we get that limited partnership. So if someone wants to be protected, have their personal assets protected, have their homes, their other businesses, those type of things protected, they can become a limited partner. A foreign limited partnership, now keep in mind foreign, when we talk about business and these type of things, we think back to a couple other lessons we've done. Foreign is in another state, all right, than the one that it's formed in. So a limited partnership is considered foreign in any state other than that which it is formed. So if it's formed in Florida, it would be a foreign limited partnership in the state of Georgia. The rights of a general partner is in a limited partnership has all the rights and powers of partnership in a general partnership. All right. The general partners have exclusive control of the management and management of the limited partnerships. Limited partner who participates in that control, once again, they can lose it. Voting rights, a partnership agreement may grant to all or a specified group of general or limited partners a right to vote on any matter. The choice of associates, no person may be added as a general partner or a limited partner without consent of all partners. In a lot of instances, if you add someone to be a partner, then you create another partnership because you have another piece coming in. Partnerships change as partners come and go. And so there would have to be an agreement among the partners that are there to this person joining into the partnership. All right. If not, we have issues where we're beginning to change the book and change the design of that partnership. So it's very important that we're covering those type of things. We're going to fall back to that partnership agreement once again, where the partnership agreement can stipulate what we're going to do with these. So in the partnership agreement, you would stipulate that if a new partner would like to join, or if a new person would like to come in as a general partner or a limited partner, these are the steps that we would take to ensure that we are following the statute to bring this person on board. All right. And that could be a vote from all the partners. That could be whatever else it may be, a certain amount of stake that they have to put in, whatever it may be. You can list that kind of stuff in your partnership agreement. Those type of documents are very important. We get hung up sometimes on what the law requires, and we run the letter of the law without realizing that sometimes the law is just the minimum. There are other things we can do to protect ourselves. Having a legal agreement, that partnership agreement, think we just got through a contract, and think about those legal agreements that when people sign, we're agreeing to do this, we're going to abide by what we have here. Those type of things, bind people to, and members, or not members in this sense, but partners in this sense, to that agreement. So we have that partnership agreement that all parties will sign. This is what we're going to do. If someone deviates from it, then we have, look, you signed this, you agreed to this. Okay, so that is the importance of that partnership agreement. If a general partner wants to withdraw from a limited partnership at any time by giving notice, they do so. That would be a written notice. Limited partner can do that however it's provided within the limited partnership certificate, that document that's filed. The assignment of partnership interest, unless it's otherwise provided in the partnership agreement. There we go. We follow that partnership agreement now. A partner may assign his partnership interest, and assignee may become a substitute limited partner if other partners consent. All right. So what that last part is saying, and this is this part here, that a partner may assign their partnership interest, they can give it to another partner. All right. So they leave, they say, okay, you get the partnership interest in this. And if things are done, the partnership can remain or a new one formed, depending on how the partnership is set up. Profit and loss sharing. This is going to be, it's allocated among the partners as provided in the partnership agreement. Partnership agreement can be that everyone shares equal, or everyone could share based upon what they've put in. If we have limited partners, of course, it's going to be based upon their contribution. But if a partnership agreement has no such provision, then the profit and losses are allocated on the basis of the contributions of each partner actually made. So if one put in 10 grand into it, the other put 5. When we look at what we're doing here, twice the profits, twice the losses will go to one or the other. Distributions, when there's a distribution of cash or other assets of a limited partnership, that is taken care of in that partnership agreement. These are things that you need to take care of in that. Loans, both general and limited partners may be secured or unsecured creditors of the partnership. A general partner can give a loan to a partnership. A limited partner can make their contribution a loan also, so they can make loans into it. They get a higher priority in the case of dissolution. When we talk about that, they get a higher priority than just being a partner. Any partner has the right to inspect a copy of the partnership records, the records being the accounting, the books, any agreements that have been entered into, sales agreements, service agreements, any type of contracts. A partner has the right to view those. They have to do so with the right, in a right manner, a manner that is not to be damaging to the partnership, in a manner that is meant to look out for the best interest of the partnership, similar to what we'll talk about later on in a couple of weeks with corporations and how viewing their records as a shareholder goes. You have to do so in a manner so that you're not doing it in a manner that's harmful to any other partner in this instance, or to the partnership itself. Derivative actions, the limited partner may sue on behalf of the limited partnership, okay, if the general partners refuse to bring the action. The same way, derivative actions work the same here as they will in other steps. In a derivative action, the person bringing the suit does not win any damages or compensation that are brought about. They go to the partnership, or they would go to the corporation if it was someone, a shareholder suing. But in a derivative action, it goes to the business who, on behalf of who the lawsuit was brought. All right. So it goes to the business for which the lawsuit was brought. The duties of general partners, they owe a duty of care and loyalty. All right. So here's your fiduciary duty, and we'll talk about this several times. You'll begin to hear this word quite a bit over the next few weeks. That care of or duty of care and loyalty to general partners and limited partners, but the limited partners do not. Limited partners owe a duty to the money they put in. All right. The general partners have unlimited liability. The limited partners have some limited liability. It's for their obligations to which they have put in, the extent of that capital they've contributed to or agreed to contribute. All right, that's the extent of their liability, as long as everything is followed. Now, keep in mind, this has to be done to the letter. All right, there's deviations from what a limited partnership is supposed to look like by statute will cause that partnership to turn from limited into everyone being general partners. So it has to be followed to maintain that limited liability. All right, a good look at that is the way this is set up. It has all the rights and powers of the partner in a partnership without limited partners. A general partner does. Their liability is unlimited. One thing that's not listed here is taxes. The taxes are it is a flow through tax. It flows through the partnership into the partners. So the general partners are liable for the taxes. That's part of their liability. They're an agent of the partnership. In other words, they can sign for stuff. They can do the things that keeps it, the things that'll keep it going, whatever that's required. They have fiduciary duty of care and loyalty. None of that applies to the limited partner. Limited partner, once again, their only liability is what they have put in or they have promised to put in. When we get ready to dissolve a limited partnership, we're going to have to do so once again the same way we formed it, by following the statute and what the statute says about how we can do that. Limited partners have neither a right nor the power to dissolve a partnership unless there's some type of decree of the court that says this is going to happen. The type of events that can trigger a dissolution, expiration of a time period. They stated that they would only submit these funds or have this contribution for a certain period of time. Once that period of time is over, their obligation is over, and that would dissolve that part of it. They would not be a limited partner. If they're the only limited partner, we would revert to a general partnership. So that would dissolve that limited partnership, and the remaining members would have to, or the remaining partners would have to decide whether to continue the business or do what is called winding up. All right. So winding up is when we get ready to dissolve and start paying off what we need to pay off, taking care of each of the partners and what they're supposed to get out of it, happening of events in the agreement. So once we get to X, Y, and Z, we're going to do that. That would move it out. A unanimous written consent of all the partners. They can allow a limited partner to step away. If the limited partner was all of a sudden fall upon hard times, they could not make their contribution. They could go to the partners and say, okay, I can't continue to do what I've been doing. And the general partners could come together, do a vote, and give written consent for that person to withdraw. And they would have to decide to carry on or wind up, depending upon how big of a contribution this person was making. If they've been once keeping the partnership going and all of a sudden they can't do it anymore, well, you may have to just wind up the partnership and go ahead and finish the dissolution of it to completely be done with it. The withdrawal of a general partner normally will cause the dissolution of that partnership unless the other partners agree to continue in some way with the business, and a decree of judicial dissolution. Maybe creditors come forward, and the judicial system, the courts, say that we're going to do that. All right, distribution of assets. This is fairly the a fairly common way that how this is set up. Creditors, including partners who are creditors. So remember, there's partners who make loans, or the limited partners who make loans. They're considered a creditor. They get paid first. Partners are ex-partners in satisfaction of liabilities for unpaid distributions. If there was something that should have been paid out, was not paid out, then that needs to be settled. Partners for the return of contributions, except as otherwise agreed. And partners for their partnership interest and the proportions in which they share the distributions, unless there's some other agreement as to how we would divvy up the funds at a later time. So this is a real general version of it. The creditors can be broken down to what type of creditor they are. There is a stipulation in most states that if one of the partners owes back child support, those type of things, that would be one thing that's paid out of the partnership to cover that. So you want to make sure your partners are staying up on their child support if they have to pay it. So those type of things get priority over that last one, where it's just getting paid as a partner for whatever's left. All right. So in any business, no matter the structure, this is how it goes. When you're done and you wind up the business, the last to get paid are those who have been running it, those who have been putting in their sweat and tears, those who have been doing everything. It's going to be those creditors. It's going to be other liabilities on top of that. It's going to be the other stuff you owe out. Then the partners would get paid. So it doesn't always work in the favor of the partners, but that's the way we protect other businesses who have given loans or given them credit of some sort. All right, so that was limited partnerships. Now we're going to talk about LLCs. Now, we happen to live in a state who has some of the better LLC laws if you want to be a member of an LLC. Now, people who have tried to sue the LLCs may not agree with that, but as a member of an LLC in the state of Florida, your limited liability protection is extensive, and it is one of the easier states to set one up. They're often referred to as a Florida LLC. So they even get the Florida part added to it, whether that's derogatory or however they mean it, they still add the Florida to it to designate that the way we do it here is a little different than how it's done in other places. So by definition, a limited liability company is a non-corporate business organization that provides limited liability to all of its owners. Owners are listed as members of the LLC, and it permits all of its members to participate in management of the business. They have the ability to manage it. Normally it is set up to where the members will be given roles. They designate that as it's being formed, as the agreements are signed, as everything is set up, those type of things are done. So when you form one, it's required some substantial compliance to the state's LLC statute. All right, so you want to know what the statute is. You want to follow the rules. If you go on SunBiz to form any of these we talk about, you can download the statute and download all of the rules that pertain to it, all the laws and statutes that are added to it. SunBiz gives you access to those without a problem. It's not something you have to go digging for. You just go to SunBiz, it'll get you there. The members can be individuals, can be corporations, can be partnerships, can be other LLCs, trusts, estates, or associations. So this is open to a lot of different pieces and players to be a part of an LLC. A lot of large corporations will form LLCs to run smaller businesses. That protects the corporation from any loss, except for the money they put in to that LLC. The filings for an LLC, they require some type of central filing of articles of organization and state office, similar to what most types of business entities would do. The name of the LLC require the name to include the words limited liability company or the abbreviation LLC. This is normally somewhere where you want to use a fictitious name also in these. A lot of LLCs, good places for those. You see them around, and sometimes they're an LLC, sometimes they're not. But lawn care businesses, painting businesses, construction businesses, if they're not a partnership, any type of business where your work by the nature of it could cause you to become liable for accidents, for injuries, for any of those type of things, you probably want to look at this LLC. If you're forming a business, and I had a teacher, a professor, many years ago now that would simply say this: you're forming a business, you want to do an LLC. Anytime somebody would talk about forming a business, he would just respond with LLC. He wouldn't spend any time talking about it. He'd just say LLC, because it gives you that limited liability. You're not stepping up to the level of incorporation where you have to pay out a lot of money for all the different filings and all the different forms and all the different things you have to do with it. You're just forming a company that gives you limited liability. Contributions of a member to an LLC, that can be cash, property, services, a promissory note, some type of other obligation to contribute those things. So similar to what a limited partner had in a limited liability company, the members are doing the same thing. So basically, we've taken a limited partner, upgraded them to someone who can control the company, have a say in the running of the company, but giving them the same ability and same protection. So it's a step up from what that limited partner is. An operating agreement is a basic contract governing the affairs of the LLC, stating the various rights and duties of the members. Very important to have those. These agreements, whether it's the partnership agreement, the operating agreement, those things are so important. I can't stress enough how important it is to have those agreements, those legal documents that state this is how we handle everything. All right. So you cover and you try to look ahead. Always when you're doing these operating agreements, partnership agreements, any of those things, you want to look ahead. You have to try to just kind of, become prescient for a second. Think further into the future than what you're working and what could happen, what could be an issue that arises, and we're going to fix that. We need to fix that type of issue. All right. Then foreign, once again, foreign, any other state than where it was formed. So the rights of members, the rights are fairly extensive. The rights of members are the member's interest in LLC includes financial interest, a right to any distributions, the management interest, which consists of all of the rights granted to the member by the LLC operating agreement and the statute. They share in the profits and losses. They share in distributions. A member may withdraw and demand payment of their interest upon giving notice specified in the statute of the LLC's operating agreement. The importance of the agreement really comes into play there, stating how much notice a person must give if they want to, or a member must give if they want to withdraw from the LLC. And the management, if there's nothing to the contrary of it, then each member has equal rights in the management of the LLC. But they may be managed by one or more managers who may be members. It's always good to have a set management. Having too many people, too many cooks will spoil the stew. Having too many people trying to run stuff will come back and get you. So having managers set up through an agreement with the other members is always a good thing. They have LLC statutes can specify voting rights of members, subject to any contrary provision in an LLC's operating agreement. Information. LLCs must keep basic organizational financial records. Each member has a right to those. Any derivative action, a member has a right to bring an action on behalf of the LLC to recover a judgment in its favor if the manager or members with authority to bring the action have refused to do so. Assignment of LLC's interest unless otherwise provided in the operating agreement. A member may assign a financial interest, and assignee of a financial interest may acquire the other rights by being admitted as a member of the company if all the other remaining members' consent or the operating agreement provides. So we have a couple of things here that the operating agreement will answer questions and not leave things up to trying to figure out. Once again, the importance of an operating agreement. Same as with the partnership and the limited partnership. The importance of that agreement of how things are ran, how the company is going to go. The importance of having that agreement prior is so when we need to assign interest, when someone's leaving, when someone decides that there needs to be a vote, when we have all these things happen, which will happen. All right. Someone's going to decide they want to withdraw from the partnership. Someone's going to decide they want to withdraw from a LLC. When that happens, we need to have something in place that states this is how it's going to be handled. If not, you're going to have to try to manage it on the fly. And you're going to have a whole bunch of different personalities trying to make these decisions. Some may have liked this person, some may have not. You stand a chance of something as simple as someone just not wanting to be a part of the company anymore, ruining the company from the inside out. The agreement can help stem that to a certain extent. All right, so we want to be able to do that. Manager managed LLCs are ones where we have a manager in place who takes care of that stuff that we need taken care of. They have a duty of care and loyalty. Usually members of a manager managed LLC have their duties to the LLC or its members by reason of being members. Member managed, the members of the member managed LLC, y'all try saying that fast, have the same duties of care and loyalty that managers would have in a manager managed one. All right, liabilities. No member or manager of an LLC is obligated personally for any debt, obligation, or liability of the LLC solely by reason of being a member or acting as a manager of the LLC. Right here, I want to stop with the liabilities the same way I did with the other. Talk about taxes for a second. Taxes are done exceptionally well with LLCs because you get to decide. You can pay it as a corporate tax. In other words, pay the tax but as the LLC. The LLC itself will take care of the taxes, or you can do a flow-through tax where it's spread among the members. All right, so you have the option, and that option can be chosen different each year. You can file 1 year as one, file 1 year as the next. All right, so that is another plus to the LLC. LLCs are, sound pretty good when you start looking at them from a lot of different angles. When you look at your liability, your ability to choose the taxes, your ability to do a lot of different things with an LLC. All right, so you can choose how the taxes are done, have a flow-through tax where it's paid by the members, or have it done as a corporate tax, as a company tax, and the LLC itself would pay those taxes. If we're going to dissolve one, an LLC will automatically dissolve upon the expiration of the LLC's agreed duration or any event that's specified in the articles that would cause dissolution, a written consent of all the members, or decree of judicial dissolution. Fairly similar to what we looked at with limited liability partnerships. With dissolution, we have a disassociation. It means that a member has ceased to be associated with the company through voluntary withdrawal, death, incompetence, expulsion, or bankruptcy. A winding up is a completing unfinished business, collecting all debts, and distributing assets to creditors and members, also called liquidation. The authority to do so of a member or manager to act for the LLC terminates, except so far as may be appropriate to wind up LLC affairs. All right, so that authority that all the members have, except for those who are handling the winding up of affairs, they would cease to have any authority to make decisions or anything along that line. That apparent authority will continue unless notice of the dissolution is given to a third party. So the third parties have to be notified that, hey, this is it, we're done. No one is a part of this anymore, and you got paid what you got paid. All right, the distribution of assets in this. Once again, we have creditors on top. Includes members or managers who are creditors. The members are former members in satisfaction of liabilities for any unpaid distributions, in other words, money they're owed. Members for the return of contributions, and members for their LLC interest. Once again, it's that order, the last in line are those members who have made distributions or, which share in distributions. They've put in blood, sweat, and tears, those type of things. All right. So that's how that kind of changes. A merger or combination of assets of two or more business entities into one of the entities. The surviving entity receives title to all the assets of the merged entities and assumes all their liabilities, and merged entities cease to exist. That'll be real similar when we start talking about corporations and how some mergers work with that also. All right, a couple of other types. We have a limited liability partnership. So remember, the other was a limited partnership where that limited partner was only, the limited partner was only in for whatever they put in. The general partners were liable for everything else. Limited liability partnership takes that limited liability status, gives it to all the partners. General partnership, that by making statutory required filing, limits liability of its partners for all or some of the partnership's obligations. They basically step up, make everybody limited, make everybody's liability limited by doing that. Most statutes require only a majority of the partners to authorize registration as a LLP. Others require unanimous approval. LLPs are where a lot of your professional groups will fall into. They'll be under one set name. A lot of members of the same profession or variations of that profession will work under that umbrella name. They'll all have ownership stake. They'll all have some say in what's going on, but they'll be protected with limited liability because they'll form it as a limited liability partnership. The name of an LLP must include the words limited liability partnership or the registered limited liability partnership, or have LLP at the end. The liability limitation. Some statutes limit liability only for negligent acts. Others limit liability to any partnership, tort, or contract obligation that arose from negligence, malpractice, wrongful acts, or misconduct committed by the partner, employee, or agent of the partnership. Must provide limited liability for all debts and obligations to the partnership. We think about those professional groups again, malpractice, those malfeasance, whatever it may be, something they're doing, it would be liability to that individual, but not to the partnership itself. Limited liability partnership, that is in which the liability of general partners, or a limited liability limited partnership. A limited partnership in which the liability of general partners has been limited to the same extent as an LLP. All right, so that covers that section.